That's right.
This isn't about you. It's not about you.
That is correct.
Stop right now.
Good afternoon, Your Honor. Nicole Sadi. I represent Ms. Henderson, and she is now at the podium to my right.
Okay.
Nicole Henderson.
All right. I've received the assessment. Have the parties had an opportunity to review?
People have, Your Honor.
I have.
Go ahead. Any additional argument?
I'm sorry, I didn't hear the last few.
Any additional argument regarding her release?
Yes. Would you like me to go first?
Sure. It doesn't matter.
Okay. So, Your Honor, I see that Ms. Henderson was extremely forthcoming with Mr. Statman during this assessment. While I'm looking at Ms. recommendation, these recommendations Mr. Statman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect I showed it to him. Looks as though the police, the day that she was arrested, considering everything that they saw on the scene, was recommending a personal recognizance bond along with the scram tether. My client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before. And in terms of the actual nature of addiction and rehab, Your Honor, I would argue that that is what we see when people are breaking a habit. There is a recommendation in here that is something she has not done before. Ms. Henderson has not attended Alcoholics Anonymous before and had that type of support and ability to make some sober connections. She has never done that before. And it looks as if Mr. Statman believes, professional assessment, that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
At this point, the defense is making a strategic shift away from arguing the underlying criminal allegations and toward the only issue that truly matters during a bond hearing, whether Ms. Henderson can be released safely under reasonable conditions. Notice how counsel repeatedly relies on the professional assessment instead of simply asking the judge to trust her client. That is significant because judges generally place greater weight on structured evaluations than on unsupported promises made in court. The proposed safeguards, outpatient treatment, Alcoholics Anonymous, and a scram alcohol monitoring tether are all designed to reduce future risk rather than dispute guilt. Just as importantly, the defense acknowledges Henderson's addiction history instead of minimizing it. That approach can strengthen credibility because it recognizes the court's concerns while presenting a concrete rehabilitation plan. But will the judge view these conditions as enough to protect the public, or will the seriousness of the alleged intoxication outweigh the proposed safeguards? At this stage, the hearing is becoming less about punishment and more about risk management, accountability, and whether structured supervision can reasonably replace continued detention.
You're having just two brief things. One, just a slight correction from what was just indicated about the information form. Where I believe the council looking, that was the people's original recommendation at the time of charging something we pulled out, not the police. Certainly that was the charging EPA's recommendation. The case, and when the case was first brought before this court, I asked for more than a PR bond for the reasons I indicated on the record. I know that doesn't factor into the court's decision today, but I just wanted to correct that. The second matter or the second piece that I wanted to discuss was in my review of the defendant's version of events as told to Mr. Statman, that they differ from what I believe the report and the evidence shows, not too dramatically, but in ways that I think it's important for the court to be aware of. Specifically, one part in the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the three tests, to my understanding. The other two were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection of the event might not be the best. I don't think there was any malice on her part. But I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is a paraphrase, and I would also like to say that
Why?
Henderson.
Can I ask why you're going down the path that you're going down?
Yes, that he's paraphrasing that Mr.
But why are you?
Paraphrase.
Why does? Go ahead.
Okay, there may be an inconsistency here, but that doesn't mean there's an intention to be inconsistent, is where I am going down this road. I think you understand. I don't need to go further. The other thing I did want to address for this court's attention is while Ms. Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points.
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science for my client to pursue.
Why do you think I asked for the assessment, counsel? Really? Why do you think I asked for the assessment?
Well, Your Honor, my job's to advocate for her.
And it'd be good if you did that. But why do you think I asked for the assessment?
I can only go by what you said. I'm not in your mind, but you said that you were concerned about my client's health. You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
So why can't I get arguments that go toward that?
This, in my opinion, this does go towards that. When we're looking at blood draw this high, the science shows, and
You know what? I mean, I'll let you go. I'm going to do what I want to do because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. I've been trying to do it with as many safeguards as I possibly can get. Trying not to miss anything. That's what I'm trying to do. I don't know that the arguments you're giving me help me any way in that.
Your Honor, respectfully,
That means I'm going to get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you. It's
right.
not about you.
That is correct.
Stop right now. Deputy, take her back into lockup. Court's going to stand in brief recess. All right. Yeah.
This exchange reveals one of the most important courtroom dynamics in the hearing. Judge Simpson repeatedly tried to redirect the attorneys toward the purpose of the bond assessment, which was evaluating Henderson's treatment needs and the safest conditions for release. Instead, portions of the argument drifted into debating scientific interpretations of blood alcohol levels and factual inconsistencies that the judge had already signaled were not central to the immediate decision before him. The courtroom tension escalates when defense counsel characterizes the judge's comments as unfair. From a procedural standpoint, judges have broad authority to control the scope of argument during hearings, particularly when they believe counsel is moving away from the issue under consideration. Did you notice how the judge repeatedly asked, "Why do you think I asked for the assessment?" That question wasn't rhetorical. It was directing everyone back to the legal standard governing bond. Importantly, nothing here suggests the judge had abandoned the possibility of release. Instead, his frustration appears focused on keeping the hearing productive. The brief recess demonstrates how courtroom management sometimes becomes necessary before a substantive ruling can be delivered.
but they rub my temples. Court recalls the case of People versus Anderson.
Good afternoon again, Your Honor. Raymond Cook for the people.
Good afternoon, Nicole Sadi, present, and my client is standing to my right.
I'm going to dispense with any further argument, if that's what we want to call it. What I'm going to do is defendant's going to be released on a personal recognizance $25,000 bond. Prior to release, she must be placed on a scram tether. So, ma'am, you won't get released right away, but they'll come and fit you with a scram tether, and then you'll be released. I'm going to order as a condition of her bond, your programming through, because you're employed at GM, right?
Yes.
And so I'm going to indicate also that the defendant is to engage with, is that GM or UAW program?
Well, it's called Rivers Bend, so I'm not.
It's called what?
Rivers Bend, the IOP program.
It's through GM.
Can I say something?
Hang on a second. I'll do it this way. That you're to engage with General Motors Employee Assistance Program, whatever their program is. You wanted to say something?
Yes. During my assessment today with Matt Statman, I had told him that I wouldn't mind. I would like to do the Dawn Farms program. That's $40 a week, outpatient.
Here's what, so that we know. This assessment gives me one sort of side of view. All right. The Employee Assistance Program, I want you to engage with GM's Employee Assistance Program because that's available to you. Okay. I'll indicate that you're also to engage in Dawn Farm programming. I'll make that a condition of your bond, but I understand if one program is there, that might be a bit much. But okay, so I'll make that also part of the order. And then, is there anything else from either side on?
Nothing from the people.
May we briefly approach, Your Honor?
Yes.
Thank you. Yeah, shall be done. That's
Back. Teachers are. Oh, because it shows my face scrunch. As if we have a quick in chambers.
I think we're doing that, sure.
Okay. All right. We're all set.
Thank you.
Thank you.
You're welcome.
The final ruling illustrates how bond decisions often balance public safety with rehabilitation, rather than functioning as an early determination of guilt or innocence. Despite the courtroom conflict that unfolded earlier, Judge Simpson ultimately granted a personal recognizance bond with substantial protective conditions attached. Those conditions, including continuous alcohol monitoring through a scram tether, participation in the employer's assistance program, and enrollment in the Dawn Farm outpatient program, directly address the concerns identified in the assessment, instead of simply releasing the defendant without oversight. Another detail worth noticing is that the judge remained focused on available treatment resources. Rather than treating the defendant's employment benefits as irrelevant, he incorporated them into the bond conditions, ensuring she uses existing support systems before seeking alternatives. That reflects a practical judicial approach aimed at increasing compliance while reducing future risk. The earlier disagreement between the court and defense counsel may have created dramatic courtroom moments, but it did not ultimately dictate the outcome. The judge separated the procedural conflict from the legal question before him, which is an important lesson about judicial decision-making. Do you think the defense's arguments ultimately helped, or did the professional assessment carry the greatest weight? And would the result have been different without the detailed treatment recommendations already before the court? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.